To proceed with the state of Florida versus Okafor. Counsel?
Good morning, Justices. May it please the court. My name is Doris Meacham. I'm an Assistant Attorney General with the state of Florida. I represent them today in the matter before you. The respondent in this case, Mr. Okafor, is also one of the dozens of defendants whose death penalty sentences were vacated pursuant to Hurst. In this case, Mr. Okafor was convicted of first-degree murder, 2 counts of attempted murder, and armed burglary of a dwelling. The verdict came back 11-1 for the death sentence. On direct appeal, this court affirmed his conviction but vacated his death sentence because it was not unanimous pursuant to Hurst. The state filed a motion for rehearing, which was denied, and the mandate was issued in May of 2017. Mr. Okafor has yet to be resentenced, and the Poole decision that came out recently prompted the state to file a motion to reinstate his death sentence. Okafor was one of 4 motions to reinstate the death sentence in which a mandate had been issued. The 3 other cases are currently pending before this court. I believe it's Smith, Williams, and Belcher. In those cases, the trial court judge did grant the state's motion to reinstate, citing to Brunner, to Marshall, to Owens, and to Morales, stating that the intervening change in the law and controlling law changed the mandate and no longer made it valid. And based on that, they were bound to follow the new law in Poole. And based on the new law in Poole, Okafor is not entitled to a resentencing. Poole eliminated the unanimous jury recommendation, and he otherwise meets the requirements set out in Poole with the aggravating circumstance.
Counsel, let me ask you this. Why isn't the new law the statute that the legislature adopted? I mean, that's the law that governs now. I mean, it is, as was pointed out by one of the justices in the last case. Poole establishes some constitutional law, but as far as what is actually required in the death cases now, the statute establishes the framework for that, which goes beyond what Poole requires.
It does. What the state's position is that right now the lower court has a mandate or a prior or a post-conviction order, which states that because of Hurst, which was at the time the law of the case, the defendants were entitled to a resentencing. What we're arguing is that the law of the case is no longer controlling. The law of the case now is not Poole, but not Hurst, but Poole. And in exceptional circumstances, the court may deviate from the mandate because there's been an intervening change in the law, which changes the decision that was made in that mandate. What we're looking at right now is the fact that, as his mandate stated, he is entitled to Hurst relief because that is the law of the case at that time. He is not entitled to Hurst relief in 2020. We're not arguing that the statute is incorrect. It is. What we're arguing is that there are exceptional circumstances in this case which requires the trial judge to reconsider the mandate before them, to consider the new law.
But trial courts don't reconsider mandates.
And that is correct. They're not.
We issue mandates, and there's a period, there's a statutory period in which we can recall our mandate. But the curtain on that closed a long time ago.
Right. And we're not asking the court to recall a mandate. We're asking the.
But let me ask you, and I understand that, but why isn't this just effectively asking us to recall the mandate in another form? I mean, it's the same result as if we recalled our mandate. But you're asking us to do something that we get the same result that we would be prohibited from doing if we recalled our mandate?
Well, we would be doing what's been done before. As I stated, the lower court judges that granted the state's motion to reinstate cited to several cases which stand for that proposition, that we can change the law of the case based on extenuating circumstances, such as a change in the law. This court itself in State v. Owen did just that. In State v. Owen, the defendant's case was remanded back down. His conviction was vacated. So was his sentence because they admitted.
But counsel, it seems to me that the difference there is the new law then was the decision that we had made. Okay,
right.
The new but in Owen, and I don't see how you get around what Owen required, which was a new trial. Applying the new law. Here, that's what will happen. There will be a new proceeding applying the new law. So I don't understand how you find much comfort in Owen.
In Owen, what happened in Owen was that they vacated his conviction because of the admissibility of his confession. At the time, they were not supposed to let it in based on the law at that time. Before his trial took place, there was an intervening change in the law by the U.S. Supreme Court in Davis. Now, the state asked for a remedy. Before going forward with the trial, they asked that this court apply the new intervening change in the law, which basically invalidated the mandate, the reasoning in the decision in Owen. And this court agreed. They changed the law of the case. They changed the rule of law would no longer be Owen, but it would be Davis when they went forward.
The state did not get the remedy that they sought to the extent that they were not just allowed to have the earlier conviction reinstated.
Right, they did not get that remedy.
The court decided that there would have to be they said that we will not go that far.
Exactly.
There'll have to be a new trial. But recognize that at the trial, the law that would govern was the new law that had been established based on a U.S. Supreme Court case. Now, I don't see how that provides any refuge for you. I mean, you've got to jump over the requirement, the distinction here that the new law is the statute, and that. That has been amended by the legislature. And furthermore, you've got to somehow get over the fact that the court required a new trial, even in those circumstances. So how do you get around?
Well, the state was asking for two remedies. They were asking that the new law would be applied to the confession going forward. And we agree that they did not reinstate the conviction. And that's not what we're asking for here. Mr. Okafor's conviction was affirmed on direct appeal. That's a completely separate issue. What we're stating right now is the mandate said that he was entitled to a resentencing pursuant to the law in Florida at the time, which was Hurst. What we're asking for is a similar remedy as in Owen, is that you apply the law in Poole rather than Hurst. And if you apply that rule in Poole to Mr. Okafor's case, he is not entitled to a resentencing. His penalty phase proceeding was constitutional. Everything was met. If you apply Poole to the facts of his case, then there is no longer a need to resentence him. We're not asking for such a dramatic request as reinstating a conviction. We understand that that's more than Owen was asking for. You weren't going to go that far with the conviction.
Well, let me tell you, reinstating a death sentence is pretty dramatic. Wouldn't you say?
It is, but not when it was already constitutionally reached. The proceeding was never unconstitutional.
Well, your logic applied to Owen would result in no new trial because the confession was entered. It wasn't unconstitutional, the use of the confession. And so they could have just said, well, reinstate the conviction.
Right. I mean, what we're asking for is not necessarily an automatic reinstatement. We're asking that the trial court have the discretion to deviate from the mandate and apply the new law. The lower courts also cited to Brunner. That was another case. That was a civil case in which there was a foreign corporation doing business in Florida. They sold some stock out of state, and they were supposed to pay taxes on the gains from that sale. Went to this court. This court said, yes, you are liable to that. It remanded it back for further proceedings, just as this case was remanded back for further proceedings that have yet to take place. Prior to the proceedings going forward in Brunner, there was an intervening change in the law, which again invalidated that mandate. It pretty much said that Brunner was not liable for those taxes. So again, it went back, and this court said that we would, because of the exceptional circumstances in this case, with the intervening change in the law by the U.S. Supreme Court, that would now be the law of the case. So you would apply the facts of that new law to Brunner's case, and he was no longer liable. So that's another instance in which the court considered the fact that an intervening change in the law basically invalidated the entire premise of that mandate. And if you would just change the law as it stands today with what the prior opinion was, he is no longer entitled to relief. Again, another case is Morales. That was also a case in which it went up because of sentencing issues. It was remanded back down for the sentencing to take place correctly. There was an issue with the sentencing order that was done. Prior to him being resentenced, there was an intervening change in the law, again, invalidating that mandate. And the court did not enforce the mandate based on the intervening change in the law. What we're asking is the same premise to have happen here, is for these mandates that are no longer valid based on the law, based on Hurst, to be reviewed again to see whether or not they fit the requirements of Poole.
Counsel, could you address the jurisdictional issue? Because I'll just be honest with you, I worry about the precedent that we would be setting by extending our, obviously not crystal clear case law on the all writs petition, but I'm having a hard time seeing how we even have the jurisdiction to entertain what you're asking us to do in the first place.
Well, as stated earlier, this court has exclusive jurisdiction over death penalty cases, including those cases in which the death penalty has been vacated and sent back down for further penalty proceedings, which is what this case is about. And we also have no other adequate remedy. We're trying to preserve this court's ultimate jurisdiction, not only in Mr. Okafor's case, but in all of the other cases that are out there that are pending resentencing pursuant to Hurst. And there are many.
How are you preserving our jurisdiction, though, when we lost our jurisdiction over this case when the mandate period ended a couple of, or however many years ago it was?
It hasn't lost it. As it's still pending resentencing. Until he receives a different sentence, this case still maintains jurisdiction according to the case law. He has not been resentenced yet. And that's another reason to look at whether or not we should change the law of the case here, whether or not the trial courts are allowed to deviate. This case is still pending. He has not received any Hurst relief. There are no finality interests that are being destroyed in this case. He has not been resentenced. And for the courts to blindly execute a mandate, knowing that that's not the law of Florida any longer, is not justice. Justice Lawson, as you stated, you made a concurring opinion in this case on direct appeal. And you stated, at this time, Hurst is the law in Florida, whether I like it or not. And I give Hurst relief because that is what a faithful application of Florida law is needed. That's what is supposed to be done. And just as you as are supposed to follow the current law, so are the lower courts. It's a faithful application of the law as it stands now. At this time, Hurst is no longer the law in Florida. Poole is.
It seems like if you frame it that way, though, then you're asking us to violate the law by ignoring the statute that says that our authority to change the mandate runs out after a certain time.
We're not ignoring the statute. We understand that that's For cases that are pending right now, or it's a different posture here. The only reason that Mr. Okafor is being resentenced was because of the mistake in law that was made in Hurst. This court receded from that mistake in law in Poole. What we're asking now is for these remaining cases that have not been resentenced to continue that mistake in law. There's no constitutional basis to go forward with these resentencings when they were already constitutional. That's what Poole stands for. That's a different posture that we're in right now with these cases.
Counsel, you are now in your rebuttal time. You may continue, but you are consuming the rebuttal time.
I will reserve my time. Thank you.
Mr. Allen.
May I please the court? We had asked that counsel for amici precede me, but it would be Elliot Shirker, and the clerk's office said that was communicated to the court. If that's all right with the court, Mr. Shirker will begin, or I will, whatever the chief decides.
Mr. Shirker may proceed.
Thank you.
Thank you, Your Honor. Elliot Shirker on behalf of the amici. As this court said once, all things must end, even a court's power to correct inconsistencies. The reason for this forms the bedrock of Anglo-American jurisprudence. There must be an end of litigation, public policy, as well as the interest of individual litigants demanded. That is what this court said in its 1981 decision in State Farm versus 5th District, quoting a principle that was established in its 1892 Lovett decision. The principle that this court applied in State v. Owen, a decision that is materially indistinguishable from this case. As this court held in Owen, our prior decision, which reversed Owen's convictions and remanded for new trial, is a final decision that is no longer subject to rehearing, even though the basis for the reversal had been eliminated by a post-decision but pre-new trial U.S. Supreme Court opinion. The Florida legislature has now spoken definitively with its 2013 adoption of Section 43.44, which this court has incorporated into Rule 9.340 and elsewhere in the Florida Rules of Appellate Procedure. That statute has 3 sentences. It says, first, an appellate court may, as the circumstances and justice of the case may require, reconsider, revise, reform, or modify its own opinions and orders for the purpose of making the same accord with law and justice. It says, second, how the court does it. Accordingly, an appellate court may recall its own mandate for the purpose of allowing it to exercise such jurisdiction and power in a proper case. And third, establishes a time limit. A mandate may not be recalled more than 120 days after it has been issued. Finality thus comes 120 days after the mandate. Now, every civil practice.
Is that procedural?
Your Honor, that's not been briefed in this case. I'd submit it's entirely substantive. It creates a power in this court and then secondarily regulates that power. It would be a classic instance of a mixed statute in which the procedural aspects enforce and regulate the substantive aspects. In any event, this court's adopted it as a rule. So it's in both the statute and the rule. Every civil practitioner who prevails on a first round of appeal, Your Honors, is inevitably faced with the question of, when will this thing be over? Can I close on the contracts? Can I get my financing? Can I start pouring concrete? And many variables have to be taken into consideration in answering that question. But the one thing every practitioner has known, at least since 1892, is that the issuance of a mandate and the expiration of the recall period, whether it's a term of court or now 121 days, means that the appellate court's decision is immutably final unless it is overturned by a higher court. The position urged by the state we submit would overturn more than 120 years of precedent and eliminate any certainty that a mandate's issuance and the expiration of the recall period equals finality. No decision would be truly final. Now, this case is a particularly dramatic example of a post-mandate change in the law, but the state's proposed rule could not be cabined to such dramatic changes. Those of us who spend considerable periods of time, portions of our days rather, on Westlaw are used to seeing phrases such as abrogated in part by, or overruled in part by, or questioned by. The common law is fluid and organic. Resourceful lawyers under the regime proposed by the state would be able to take advantage of any change in the law to try what the state is trying to do in this case. There would be no finality, no certainty in any appellate decision. As this court noted this morning, and as it said in Owen, we are unwilling to go that far. The court should not now go that far. what this court said in 1926 in Washington versus State is still true. The term of court in which said judgment was entered has long since passed, and the question arises, can this court recall or vacate said judgment? This can be done now. It can be done 20 years from this time, and there's no telling when litigation would cease. The exercise of such a power, if it existed at all, would be the most uprooting and dangerous act ever exercised by any court. No such power, however, exists. Thank you.
Thank you. Mr. Olive.
May it please the court. I, along with Mark Burnham and Sandra Woodall, are appearing for respondent. Mr. Burnham and Ms. Woodall were preparing for resentencing in this case, which was scheduled March 9th when the state filed this petition. Before I begin, I'd like to compliment the court and thank the court staff for the work done to pull off an oral argument like this. I've become acquainted with Zoom the hard way and understand how difficult it is. I don't understand all the solutions, but Mr. Chief and Justices, your staff did a remarkable job and they're to be praised.
Mr. Olive, would you concede that that in the underlying criminal case, that the order that we're talking about doesn't meet the test for the traditional test for a final order, in that it leaves additional judicial labor? I mean, a criminal case isn't done until the defendant sentence is entered. So, I mean, I recognize that we've treated it differently from that by rule and in legal precedent, but I mean, it's not final in the traditional, applying the traditional test, correct?
Well, it's final in the sense that this court has ordered a new capital sentencing proceeding, and what the state is asking this court to do is to itself reimpose a death sentence.
Well, I understand that, but I mean, this type of, we could have just as easily had a procedure by which we could have said that the post-conviction is a continuation of the criminal case, and that an order that sets aside a sentence is a non-final order, and we made it appealable or not. I mean, it's in terms of the underlying criminal case, it is final only because that's what we've labeled it. There wouldn't have been anything legally incorrect about labeling this as a non-final order and then either allowing or not allowing the appeal until after the sentence. I mean, we could have gone that route. There's no, correct? Because the judicial labor is not complete in this criminal case until the sentence is imposed, right?
Well, this isn't a 3850, of course. This was a direct appeal.
Right.
And whatever the rules are on 3850 may apply, may not apply. But in terms of it being a direct appeal, it's final. You said this judgment is wrong. It violates Hurst. You get a new sentencing proceeding, and the time lapsed that the state could seek reconsideration of that or recall the mandate, and down we go. And what he's entitled to now, I mean, it's more analogous to Owen, as the court has said several times. And in Owen, the court said, we're not willing to go that far, as the chief mentioned earlier in the last argument. And going further into Owen, our prior decision, which reversed Owen's conviction and remanded for a new trial, is a final decision. Same thing here, which is no longer subject to rehearing. Owen stands in the same position as any other defendant who has been charged with murder, but who has not yet been tried. Mr. Okafor stands in the same position as someone who's been convicted of murder and has not had a sentence determined. Just as it would be the case of any other defendant, the admissibility of Owen's confession will be subject to the new rules. However, Owen's conviction cannot be retroactively reinstated. Well, I do think, Justice Dawson, that we're in the same position as the Owen case, and it should control. The state makes several arguments about why jurisdiction is appropriate here. The first one is that the decision in Hurst v. State was unconstitutional ab initio and thus it's void. There's no citation in the Marbury versus Madison for that proposition at page 4 of the petition. And what Marbury says, of course, is an act of Congress that's repugnant to the Constitution is void. It also says it's emphatically the province and duty of the Judicial Department to say what the law is. That's what happened in this case. Justice Lawson, when you decided, I disagree with it, but it's the law of the land, you didn't say, but oh, it was unconstitutional. What that court did was unconstitutional. Nowhere in Poole does this court say any language that would make Hurst, quote, void of initiative. The court did, and this is when I think it was Justice Nunes said, I'm worried about precedent. The state argues for jurisdiction, citing Strazula at 11 and 12 of this petition. But what that case actually says is where litigants have once battled for the court's decision, they should neither be required nor without good reason permitted to battle for it again. And this is where the worry about precedents comes in. Perhaps the good sense of which Judge Hand spoke comes to a calculus of the relative unseemliness of the court's altering a legal ruling as to the same litigants, with the danger that this may reflect only a change in the membership of the tribunal. Now, I've been practicing before this court for 35 years, and it's been called a lot of things. It's been called brave, it's been called justice seeking, it's been called predictable, uniform. It's never been called unseemly. And I am fear that the state, if it convinces the court it should go down this path, it would be unseemly, and I sense that some members of the court feel the same. Let me argue some practicalities that are illustrated by this case, and what would happen if the court did what the state suggests the court should do. As the court is aware, and this is argument 3 in our reply to the petition, the death penalty cannot be inflicted in an arbitrary and capricious manner. At least 33 inmates who got Hurst relief, and it's interesting, the state says you don't get Hurst relief until you've been resentenced. Where does that come from? Every justice that I have spoken in front of, every lawyer or prosecutor I've ever spoken to before has said Hurst relief is the Supreme Court or 3850 court granting a new sentencing proceeding. Hurst relief isn't getting life or death. Hurst relief is getting the relief that was granted in this case. And at least 35 Florida inmates have been resentenced to life based on Hurst. And to come in and snatch the same right to relief away in this case is arbitrary. And the arbitrariness of it is reflected in this case just in court calendars. The respondent was appointed an attorney. The attorney decided to run for judge. Honorable profession, but it required him to withdraw. And then new counsel were appointed. Well, had previous counsel been there, we could be in the 36. He might have gotten a death sentence, but he could be in the 35. And it's just an arbitrary thing when his case came forward. And then the next thing is, in Orange County, there was a ruling that only one death case could be tried per month because of personnel. And it could be a Hurst resentencing, or it could be a brand new case. And so the case is stacked up. And so just court dockets and the inability to provide counsel on a consistent basis made the state able to file this motion in this case. So it's utterly arbitrary and sort of a whipsawed way to go about the representation or the argument provided by the state. I wanted to talk a little bit about Poole and some of the problems that arise from applying Poole to our client. There's virtually no.
Mr. Oliver,
Yeah.
could I interrupt and ask you a question? With respect to that, on page 14 of your response, you say that Poole is irreconcilable with the Eighth Amendment's requirement that the ultimate decision to impose a sentence of death rather than life must be made by a unanimous jury. And I'm interested in that assertion of the legal principle with no citation whatsoever. Where do you find a case that says that the Eighth Amendment requires that the ultimate decision to impose a sentence of death must be made by unanimous verdict?
Well, our argument, Justice.
I'm not interested. I'm not asking for your argument. This is an assertion of what the law is, and I'm asking where you got that from, because I haven't found a case that says that.
Well, unanimous jury sentencing in a capital case is a fundamental necessity, and I cite Justice Zaldivar sending. Is that where we're talking?
Yes.
Okay. And we also cite
But I mean, you would concede that that assertion of the law is inconsistent with United States Supreme Court precedent, most recently McKinney versus Arizona, correct?
the Supreme Court hasn't said this specifically, but it has said that the evolving standards of decency in a civilized society do drive the answer to the question. And the dissent by Justice Zaldivar explains how it is the evolving standards of decency. I understand that you, Justice Lawson, filed a concurring opinion discussing Florida not being an outlier or it not mattering if Florida is an outlier. In your decision, I think it's fair to say, relies heavily on Spaziano. And Spaziano, according to Hurst versus Florida, the logic has washed away, or time has washed away. Time and subsequent cases have washed away the logic of Spaziano and Hildwin. So I think Spaziano is doddering at least, and probably on his last feet. But
you recognize that the Florida Constitution doesn't allow us to get ahead of the United States Supreme Court in determining what evolving standards of decency require. You agree with that, right?
That's what the court held, certainly in Poole.
I mean, that's what the Constitution says, the People's Constitution. Wouldn't you agree?
I agree with that.
Okay, and the U.S. Supreme Court hasn't overruled that principle in Spaziano. Spaziano says that jury sentencing is not required as in Eighth Amendment case. I mean, in capital cases, correct?
The court is not under the Eighth Amendment. That's correct. But you also look at Harris versus Alabama with Justice Stevens dissenting. You look at Ring with Justice Breyer concurring. You look at Reynolds versus Florida with Justice Breyer, and you also look at Justice Sotomayor in Reynolds. And so the numbers are adding up, and I'm just saying that I overstated the argument. I apologize for that. But I think it's a serious problem with the case with Poole, because there's very little, almost no juror involvement at all in certain circumstances under the Florida statute, most especially when there's a prior conviction that satisfies the requirements for prior conviction. And it's one of the biggest problems that will be faced with respect to the Florida statute and Poole is that the jury continues to be told that your decision in this case doesn't control sentencing. I, the judge, am the senator. In this particular case, the jury was told that. And the jury was told with respect to a prior violent felony, during guilt innocence, don't worry about your findings on guilt innocence, I'm the senator. And then at sentencing, the judge said, you already found this aggravator. The jury really played no role in this case at all. And we think that's a problem ultimately under Poole, is the denigration of the jury altogether. So we think that this case is a case about finality of judgment, and in particular about whether prosecutors can be given a special privilege to relitigate cases that were closed by mandate from this court. We've got about 15 seconds if there's other questions. If not, thank you.
Thank you, counsel. Rebuttal.
Under Poole, Okafor's death sentence is constitutional. His penalty phase proceeding was constitutional. The reason it was vacated was that the jury came back with an 11-1 and it was not unanimous. According to Poole, his death sentence is constitutional. And to ask the lower courts to go forward with a resentencing that is no longer necessary is not justice. Hurst was a radical departure from years of settled Florida law. Poole has regained some of that stability in stating that a jury does not have to come back with a unanimous decision. There is case law that Respondent did not even acknowledge, which was Brunner, which was Strazula, which was Morales, Marshall, in which it basically mirrors the facts in this case. The trial court in Marshall did not enforce the mandate because of the intervening change in law. They stated that the manifest injustice exception to the law of the case results from an intervening decision by a higher court. And the appellate court permitted the trial court to strike the resentencing, even though there was a mandate in place because the intervening change in law invalidated that mandate. That's what we have here. It is not necessary to go forward with an unnecessary and costly resentencing based on Poole. The mandate that was issued in Poole was issued incorrectly, we see now, based on mistaken law in Hurst. And what we're asking is for the lower courts to have the discretion to deviate from that mandate, to not enforce that mandate because it's no longer valid because of Poole. If there are no further questions, we would ask that you accept our all writs petition because we have no adequate remedy to prevent the resentencing in this case, as well as the other cases that are still pending resentencing pursuant to Hurst, be it a mandate or be it a prior conviction order. Thank you.
We thank both sides for your arguments. And that will now conclude today's session of court. The court will stand in recess.